Good morning. Welcome everyone to our webinar on legal considerations for open source software. My name is Robert and I'm joined by my colleague Jessica, and we're both senior lawyers in LegalVision's commercial contracts team, specialising in technology, software and blockchain matters. Just a quick note, we didn't actually decide to match today. This is just a classic case of great minds thinking alike. So before we begin, a quick couple of housekeeping matters. The first of which is that you'll be emailed a copy of this webinar recording after this webinar. Throughout this webinar, you'll be able to submit your questions in the chat box, so do keep them coming as we'll get to them at the end. And then finally, please complete the survey after the webinar. We do really appreciate the feedback that you guys provide to us, which allows us to provide these webinars for free. So also, all attendees are eligible to receive a free legal consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today, we will be discussing the legal risks and benefits of using open source technology, which types of legal contracts are used in the open source sphere, the software licensing sticking points when using or contributing to open source technology, intellectual property issues which may arise when dealing with open source software, and to finish up, some practical tips you should consider. Now, it's worth pointing out that the majority of open source software licenses available are developed by either American or European lawyers or developers. And so the spelling they use for licenses will include the use of the letter S instead of C, as the Australians and English will use. So that's something to be aware of when you're looking for and dealing with these open source software licenses. And now Jess will provide a brief intro into open source and speak about the risks and benefits of using open source technology.
Thanks, Robert. Yeah, so I'll start off with an introduction. So we're definitely seeing a huge number of businesses adopting innovative models where they're using open source tech. There are millions of repositories on GitHub alone, and GitHub is an internet hosting service for software development. So both in-house teams and external developers are using community-sourced code from public repositories to really more effectively build and test, launch and maintain software. So as a brief summary for those not very familiar, open source is a form of publicly accessible software source code that's subject to certain license conditions, generally allowing the licensee to use, view, modify, and redistribute the open source's source code, often at no cost. So I'll point out that some may also define open source as free, in that you can view the source code for free, but it can still be paid for. Closed source, on the other hand, is where the source code and usage rights are privately owned and controlled. This is also known as proprietary software. So we're going to be speaking today about a lot of the risks associated with open source software. But one really important thing to note is that these risks aren't exclusive to open source, and many of these risks will actually also apply to closed source software as well. So you'll still be required to review and comply with the licenses and certain restrictions when using proprietary software. Okay, so let's have a look at, well, a brief look at some of the benefits and a thorough look at some of the risks. So the benefits. We definitely see that the ease of access, flexibility, and constant updates, they've made open source really ubiquitous in software development. It can be used to fast track development and expand the functionality and capability of software really quickly and cheaply. So I don't think I really need to further sell the value of open source, so I'll delve into some of the risks that we see from a legal perspective. And of course, we need to acknowledge that while open source software can be cheaper upfront compared to bespoke proprietary software, you have to consider whether it's worth it in the long run, weighing up all of the risks. Okay, so some of the legal risks. So the time and the effort that can go into ensuring compliance with software licenses means that using free open source software can be costly because time needs to be spent reviewing the license, and this is usually done by the legal team, and then implementing practical measures to comply. And this is usually done by the developers or the tech team or your external tech team. So if you're utilizing large numbers of open source software components in your company software, you'll probably need to consider the license terms of each individual piece of software and then implement adjustments to comply with any notice or attribution requirements, and then make that source code publicly available. A few more legal risks and considerations. In the software community, developers are seeing incidents of software updates containing protestware or malicious code. And these incidents highlight how organizations that are really dependent on open source software for business critical software rely on the diligence and the good faith of the open source community. So open source software, particularly that which is free, which a lot of it is, doesn't necessarily come with warranties or promises as to fitness for purpose or quality or indemnities against the infringement of third-party intellectual property rights. Instead, it comes with extensive disclaimers and waivers and exclusions of liability. So what this often means is that you can't necessarily rely on the open source software, and you don't really have any legal recourse or claims against the owner of the open source software. So it's worth pointing out here that one perhaps benefit of open source is that while you might not be able to rely on the open source software as is, might not be fit for purpose, due to the fact that the source code is available to view, you can audit it internally to ensure it complies with regulations or laws that apply to your business. I do appreciate that this can be a costly thing to do. So I want to touch on a couple of sale of business or M&A, mergers and acquisitions considerations. So where software is a key asset as part of a sale of a business, open source is very likely to form part of that software. The vendor or the seller is often required to provide warranties or promises about the extent to which open source is used or mixed in with its proprietary software. So that means that open source software can potentially undermine the extent to which a software asset can be considered proprietary, and that can then undermine the value of the sale. So businesses looking to buy or sell a business should do their due diligence on the extent to which open source is being used in the software assets being bought or sold. And then from the buyer's perspective in particular, the buyer often has lots of questions about the vendor's use of open source software. And where this happens, the vendor will need to ask their CTO or their developer or their tech team what open source software is used and how it's used. And this information might be incomplete or hard to get or patchy, and this can slow down the business sale and the transaction. Buyers might also want to see really thorough open source policies and procedures to basically assess the risk that might attach to the purchase. So that's a couple of the risks. I'm going to throw back to Robert so he'll chat through some of the contracts used in open source.
Thanks, Jess. And so I'll leave with this. So if you're an open core business, or you have a project that is or uses open source or blockchain technology, and blockchain technology itself being inherently open source, you'll need to be aware of the types of legal contracts that are used in the open source sphere. So particularly on one hand, if it's outbound, so when you distribute or redistribute that open source software, which is important to note because if you're in the blockchain space, a lot of your success is actually tied to your credibility as a project and in the software itself. And the fact that people are able to audit your code is how you get your credibility and how much you're contributing to that open source software and that project altogether. On the other hand, if it's inbound, equally as important to get across all the legal contracts. So if you're incorporating that open source software into your own software to make your own proprietary, combine it with your own proprietary software, that's when you also want to be, that's when you're categorized as inbound effectively. And like I said, really important to get across the legal contracts, really the licenses. And so let's talk about the open source software licenses. If your software source code project is intended to be open source and you're planning on making it open source, then you'll need an open source license, which is the most prominent type of legal contract you'll deal with in the open source sphere. Open source licenses will protect the contributors and the users, the project as well. So it's important for businesses and developers to be aware of the types of open source licenses available, and there are quite a few available online, which you can speak to a lawyer if you need to get some assistance on deciding which one's the right one for you. But in short, they're licenses which comply with the open source definition, which is promulgated by the Open Source Initiative. I know Jess has touched on this a little bit earlier, but the characteristics that I'll go through, which really define open source licenses, include free redistribution, so there's no restriction on selling or giving away the software as a component of an aggregate software. And there's also no requirement for a royalty fee or similar fee for any sale. About the source code itself, it must be provided or at least be made readily accessible for someone. For example, if they can download it for free, that's ideal. Ultimately with open source software, we're thinking about derived work. So what can one do with the open source software? So the license will allow for the modifications, changes, and effectively the creation of what we call derived works. And then allowing those derived works to be distributed under the same terms as the license of the original software. Now, the license doesn't discriminate, so it can't discriminate against any person, group, or persons, or a specific field of endeavor. Similarly, it should be a technology neutral. That's usually a characteristic or hallmark. So it can't be predicated, the license can't be predicated on any individual technology or style of interface, as well as the license can't restrict the use of other software to be distributed on the same medium. It can't be the case that the same medium or the other programs on that particular medium must also be open source software. Moving on, we're now going to talk about, taking a step back. So we've got open source licenses. What we can tell you is that there are generally two types of open source software licenses. So you've got permissive licenses on one hand, and you've got restrictive, or what's known as copyleft licenses on the other. So with permissive licenses, you can sell, modify the open source software code, and it's free to use. You can amend, adapt, combine, integrate the open source software code with proprietary code to create derivative works. That could be your commercial product that you want to roll out. And the requirements are fairly straightforward for permissive licenses. So, for example, any distribution of the original open source software code needs to be on the same terms that it was received in. So that said, although you are using a license that provides you with a lot of freedom, you still need to meet any notice and attribution requirements, which Jess will cover off in more detail. But ultimately, it's designed to be used with proprietary software. Now, if we look at the other side of the coin, at restrictive licenses, such as the new being GNU, GPL licenses, name says it all, they place restrictions on the licensee and what they can do with the open source software. And so generally, they can still modify or amend the original source code and build on it. But the restriction might be around how the source code is distributed or how the modified software is distributed. And that will generally have regard to the original licensing terms. And Jess will cover this off as well. The important thing to note about restrictive licenses is that they start operating or kicking in when you're in the act, or when you start distributing or redistributing the open source software. So if you're not distributing yet, if you're using it internally, the restrictive licenses won't really operate. Now, I'm going to go through some examples of commonly used open source software licenses. So moving on. Like I said, we've got the most commonly used one, the new general public license, or the GPL licenses. Most commonly used restrictive licenses, which permit commercial distribution. The GPL license, it's free. It allows software to be modified or redistributed without any restrictions or compulsory payments for the license code. The GPL license is used by developers to ensure that their code does not become proprietary when modified. And so they've got a couple of variants which have been updated over the times. And what we've got set out in that presentation slide is the order in which they are the most strongest or restrictive. And because they do vary in how strict they are, it is recommended that you speak to her to work out which one's most appropriate for your project. The Apache license, version 2, it's a permissive one. It requires the preservation and display of copyright and license notices. Under this one, contributors will also provide an express grant of patent rights to the project. And so when you reproduce or distribute the open source software with or without the modifications, you do need to give the recipients a copy of the license, and also state that you've made changes to the open source files. The MIT license, one of the favorite ones, permissive. It's also very short and to the point. Only requires the preservation and display of copyright and license notices. So you're giving credit where credit's basically due. And then finally, for the purposes of this webinar anyway, there are many other legal contracts that touch on open source out there. A contributor agreement or a contribution agreement is an agreement between an open source project and the contributors to that project. It sets out what the project can do with the contribution, how to protect the project, the users and the contributors as well. On the contributor side, it sets out what happens in terms of copyright. So it may potentially protect the contributor's copyright. And in some cases, the contributor may assign the copyright in all the contributions to the project owner, or they may grant an irrevocable license to allow the project maintainer to continue to use those contributions. Now, those contributor agreements are used by projects to provide confidence in the project. So ultimately, what that shows is it shows everyone, the project will have necessary rights over any contributions made, and to also allow for the distribution of that modified or contributed to product or software under the relevant license. So a well-drafted contributor agreement will then mitigate the risk of any disputes in relation to those contributions, such as any disputes which may arise in relation to ownership of the contributions or any other similar rights. And I'll hand it back to Jess now to take you through some of the sticking points.
Thanks. Yeah, let's run through some sticking points when accepting a software license, which you must do if you're using open source. So open source, the phrase open source or open source doesn't necessarily give you free rein to do whatever you want with that software. There are restrictions, as Robert mentioned, so I'll run through a few of those. We think businesses need to be really acutely aware of the licenses that they're accepting when using open source software and what restrictions apply. So for instance, does the license require any development work done on that open source software is made publicly available on an open source basis? Does the license require you to publish a copy of the original open source license terms with any publication of the modified code, or retain copyright notices or trademarks? And a final one, does compliance require that the source code of any developed derivatives is made publicly available? These are just a few of the restrictions you need to keep in mind. So as I mentioned before, open source software is rarely provided with any warranties or promises, and there is generally no or limited quality assurance, testing or standardization of coding methodology. And I think that's sort of how the developers work. So use of open source, use of open source software will generally be at the user's own risk. And that's inclusive and taking into account all of the license terms and software bugs and vulnerabilities. These software bugs and vulnerabilities might not be fixed as readily or as instantly as paid for proprietary software. But sort of harking back to what I said earlier, if you do have a team of developers, they then do have the freedom to fix these vulnerabilities. Okay, so a few more contract and legal tips and things to think about. So if your project collects any data or personal information on users or individuals, it's really important to comply with not only your internal company policies on the use of that data, but also any external regulations or laws that might apply to your business or the use of that data. So for instance, the Australian Privacy Act or the European Union's GDPR. Businesses also need to be really careful about offering any warranties or indemnities or making any promises in relation to intellectual property rights in their own products and IT systems where such products contain open source. It's important to be careful because you might not have a full understanding of, or you might not have those warranties from the open source provider as to whether that open source potentially infringes any third party's IP rights. If you are engaging a third party to develop or provide any software or SaaS for you, it's important to think about incorporating really robust clauses which set out restrictions on the use of open source software. For instance, whether you or someone in your organization needs to expressly consent to the use of open source software. So we do see some blanket bans on the use of open source in development contracts, but from my understanding, I'm not sure how easy it is to comply with such a clause. And then certainly, as on a more general note, if you're engaging a third-party developer, it's really important to seek warranties against the inclusion of any harmful code in what they're building for you. Okay, so a few of the considerations if you're contributing to open source repositories or projects. So it's important to determine whether your project has dependencies created by others or that includes others' code. And then where that is the case, you'll need to comply with all licenses attaching to that code. If your company allows your employees or your team to contribute to open source projects, it's wise to have an employee contribution policy dealing with prior IP and company-specific IP and distinguishing between the IP that the employee retains and that which is open source. So for instance, your team of developers might be required to notify your company if they are participating in a non-company side project. And then another perhaps general software tip not specific to open source is that you might also restrict developers on participating in side projects that compete with the company. And then on this sort of intellectual property note, Robert's going to now touch on IP issues in open source software.
Thanks, Jess. So in Australia, we're really concerned about two areas of law when it comes to intellectual property issues, which may arise when dealing with open source software licenses. That's copyright, and that's basically, whether you can copy something or not. And in the open source software licenses, we're really concerned about that right to modify, use, and distribute the underlying code. And then secondary to that is if you've got any patent rights that are associated with the underlying code or the software which incorporates the open source software. So copyright, touched on from time to time. In Australia, it's governed by the Copyright Act. And under that act, copyright is given or granted, it's provided for, and it's the copyright is in the source and object code of a computer program in the open source context. And then generally, copyright will vest in the author of that code. So, but there are exceptions actually. So, such as when an employee may contribute code which would belong to the employer. That will be dealt with in an employment contract. Patents. So the starting point here is that it is possible to patent your open source software. And if your software is open source, just be mindful that if you give people a license to use that software, if that software has been patented or a component of it has been patented, then you may not be able to enforce that patent against someone who has, rightfully received or has the rights to rightfully receive that license to the software from you under an open source software license. So there's a bit of a conflict there. You may also want to check for patent retaliation clauses when using open source software and developing your proprietary software. And that's because these clauses will effectively potentially terminate the relevant open source software license for any patent infringement or claim, which obviously would be a spanner in the works for your software development. So it's important to go through those clauses in the contract to ensure that you're interacting with open source software compliantly, but also on the other side to ensure that you're doing what you can do to maximize the longevity of that open source software project. Now, I'm going to move now to practical considerations. So I'll start with this one. So when you are designing your open core revenue model, it's really important that you identify as early as possible which features are going to be for free and which features will be premium. So which features can you monetize, which ones will be free and out there in the open for people to contribute to. More or less, you're effectively developing an IP strategy, which comes to what Jess was touching on a little bit earlier in relation to those organizational measures you can take and implement those policies. Really important to identify what's existing IP, what's your IP, what's new IP, I guess, when dealing with, when you're designing that open core model. Once you come to that, once you figure that out, you'll then be able to know what sort of open source licensing you need to use for open source software. Now, when it comes to choosing an open source software license, there's a few things you can consider here. So look to the community. So if the license, if the community that you're contributing to or depending on prefers a certain license, then just go with that license. If you can't find a license that's available, ask the maintainers. It should be. If you want something that's simple and permissive, then you can choose the MIT license, which I talked about a little bit earlier. And then at the end of the day, the key thing about open source software is we're sharing code at the end of the day for the purpose of building a project together. So think about what sort of that will then also, to the extent that you want to be able to share, will determine which license you should go for as well. One license which you probably shouldn't go for is the Creative Commons license. So Creative Commons licenses, we wouldn't be here without them, but they're frequently used in the open source sense as distinct from the open source software sense. Creative Commons themselves do openly say that it's not recommended that its licenses be used for software or hardware because of the complexities of software and hardware. So I might hand it back to Jess actually to wrap things.
Sure. Okay, well, look, that concludes the main part of our webinar. You might find our publication useful. It's called 6 Key SaaS Contract Essentials, and you can access that in the handout section in your webinar panel. We also have an upcoming event that might interest you, Landlord's Guide to Commercial Retail Lease Disputes, next Thursday. So we'd love you to sign up and attend that event. We're going to be answering your questions shortly. We've received a few so far and we'd love you to continue submitting them. And while you do that, I'll take a minute to tell you about our membership. So LegalVision membership is a really cost-effective alternative to the hourly rates that you experience with other law firms. And if you're an in-house counsel, membership is a cost-effective way to outsource additional legal work. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits. This includes unlimited document reviews, which would include reviewing your software development agreements, software licenses, contractor and employment agreements. You'd also receive unlimited consultations, so you can book as many meetings as you need with us to discuss your software licenses that you're considering accepting, or for any of your other business legal needs, not just open source specific. And you can talk to any of our lawyers, including franchising, leasing, contracts, employment, intellectual property, depending on your requirements. And your membership also offers unlimited trademark registrations and many more things, all for a very reasonable monthly fee. So we're going to answer some of your questions now. I'll start with this one. Okay, it says, you mentioned earlier that it's good to have open source policies and procedures, and that particularly in a business purchase or M&A context, business buyers may want to see these policies. Can you talk a bit about what these policies might include? Yes, absolutely. So I think it's really important to establish a position in your business, setting out the circumstances in which open source may or may not be used in software development. This policy might also set out who in your company needs to give approvals for the use of open source. And I also understand that it's a really good idea to maintain or keep a register of all open source used in your software development activities. And this register should set out in some detail the specific open source licenses or the license types used, and note any specific obligations that attach to that use. So I hope that helps. Robert, would you like to answer the next question?
Yeah, sure thing. I'll take this one. So the question is, how can I protect my intellectual property if I want to develop open source software, as well as my own proprietary software? This is a really good question. And of course, it is front and center for developers or businesses. So I'll tackle it from a business perspective. Number of ways to cut this cake. The first one is, have a look at your employment and contract agreements. If it's a scenario where you're dealing with an employee or contractor, where they're doing work for you or making contributions or whatever the case may be, to make sure that they, the IP rights in the intellectual property that they create vest in you as the business. That's one way to protect your intellectual property. And that's something we can also assist you with under the Pro membership. A more practical way of dealing with the IP is to, I was saying a little bit earlier, to develop that IP strategy. So really delineating between what is open source code and what is proprietary. And then when you start thinking about combining them together in light of your revenue model, then you can start to think about what, how you want that open source software to be licensed and distributed. And again, a lawyer can help you with that. As for your proprietary software, which is potentially a trade secret, which is a trade secret being a form of intellectual property that is protected under common law, you can use NDAs, that's non-disclosure agreements, or other contractual arrangements to protect that proprietary software. Moving to patents, so not a patent attorney, but we have patent attorneys here. Depending on how novel or inventive your software is, whether it's open source or proprietary, you can always check with a patent attorney. You can, the purpose of that really would then to see whether you can patent your software. So in terms of copyright, then mentioned earlier, the Copyright Act applies in Australia. And that grants that copyright to the author of the works, so author of the code. You can have copyright assigned in contracts, by the way. So, and then also what Jess was saying actually about the organizational measures, the policies, the employment contribution policies. If you implement them, that'll also go a long way to not only just protecting your IP, but managing your IP. I hope that helps. So I might hand it back to Jess for the next one.
Sure, okay. So another one here says, I suppose the restrictions and risks you talked about in this webinar applies to a software used, perhaps using open source software libraries and components. However, if I use open source software to build an application that provides a service, e.g. a bookkeeping service, I suppose it doesn't matter if I use open source software or closed software, correct? In other words, the issue relates to people selling software and not to people selling a service using an app that they built using open source software, correct? Okay, so I think this is a really good point and something worth discussing. I think it's still worth considering, just as I mentioned at the start, that it's worthwhile knowing which software licenses you're accepting, whether open source or closed source. It's still important to consider the risks of using open source when providing, a SaaS or a booking service, as it says, or any software product. If you're say providing business critical software, your customers or your clients are going to want to see warranties from you, or you might offer certain service levels. And so I think it's important to keep in mind how your use of open source software in your SaaS product or online platform will affect your ability to provide your product or your website or your SaaS in accordance with any agreed SLAs or contractual warranties that you've made. So I would say that yes, it's still important to, actually let me just look at the question. I would say it does still matter if you use open source or closed source. It's important to comply with all licenses and ensure that you're still able to meet your promises or warranties that you've made to your customer. Bit of a jumbled answer, but I hope that helps. Robert, what have we got next?
So we've got two good questions which I'll tackle. The questions keep coming, so I'm just mindful we unfortunately won't be able to get to all of the questions in the time we have left. And just also a quick note that the webinar is a higher level webinar of open source licenses. So if you have any further questions or comments, to just get in touch after the webinar if there's anything further you do want to explore. But I'll quickly deal with this question. Is a website intellectual property? I guess it depends. What you put on the website certainly could be considered to be intellectual property in terms of the content that you put on the website. And the website terms of use would make it quite clear what it is that is your intellectual property, as in the content you put on the website. In terms of the website infrastructure itself, if it's it's built on something like WordPress, then no, the underlying code is not. It is intellectual property, but it won't be yours to own. You can use it, but you can't exploit it. It is, you can use it and to an extent exploit it, but it's at the end of the day owned. It won't be owned by you. And will belong, in most cases, to an open source project. So look at WordPress, for example. Also got another one come in, which is we sometimes get vendors pushing back on open source software being used for services provided. How do we reassure them? Sorry, this is customers as well. So we sometimes get customers and vendors pushing back on open source software being used for services provided. I'm going to assume it's not just, actually no, it should be fine, but if you've got a combination of open source software with proprietary, I think that's fine. What you can say to your vendors and customers is that the nature of open source is pretty much built upon the contributions of a community. And so although there are, relatively, you can't really rely on some things from a legal sense, which Jess talked to a little bit earlier. It's really the notion that you have a whole community around you that's building to improve and further and extend the longevity of a project. Take blockchain, for example. the developers and the coding community around blockchain projects will always try to continue the life of the open source. So they'll fork it if anything goes wrong, and they'll continue moving forward. And as part of that community as well, what they're doing is also they're doing their internal audits. There's bounties for improving the open source software. So if developers identify bugs, any patchwork that needs to be done, any security flaws, these things are all rewarded by the community. And so what you've got is itself, you've started or you're using something that's been commenced a while ago, and it has a lot of momentum behind it that works in a very positive way. And it comes back to credibility, because the developers get rewarded for making valuable contributions. If you've got someone who's making meaningless ones or not picking up flaws, then so I guess it just comes back to the nature or the beast itself of open source software. Although you can't legally hold them accountable, you can have assurance and comfort in the fact that that is just the nature of open source software in itself. So that's how you can sort of reassure them. Obviously, you can reassure them through contracts as well that you have in place with your customers or vendors. To the extent you can, provide some comfort outside of that open source software. So typically, if there's anything that's I'm just mindful of time. I better actually hand it back to Jess to wrap things up.
Thanks. Yeah. Sorry, everyone. We've sort of got to the end of the time slot. Did want to briefly just mention a comment which I agree with, and which is worthwhile pointing out. The fact that there are indeed organizations that you can use to mitigate the risks of using open source. Things like Red Hat, Kubernetes, and lots of other software projects. So these things do exist and can certainly help mitigate those risks. So look, thanks so much for joining us. We really appreciate that you've spent the time watching and contributing. We'd love you to request your free consultation for any further discussions about this, software, contracts, or broader legal issues. And you can do that when the survey appears at the end of the webinar. So thanks so much for joining us.